both MPP for being more compare Honorable Kennedy, the fact that in what issue no. Mo compare our cases in me no. Ye, media said the assembly no. The fact that in what issue in Chesa me who no kramenka. Na ya baba me ma hwe how ade but o man quote san say ya me kan ho asem yi. E bia no Kevin Taylor follow yese 6 months deadline no atwam enti esa me call for extension of time wanye bibibia enti on what basis ana ne edi kan cross Supreme Court etimi assume jurisdiction e determine matter no because the application even the application ankasa before the court no are incompetent.
Ebuso kwame bafo Abronye ababedi nko hana no komo weni na ekodi ama Kevin Kobedu Taylor Supreme Court judges ebuso wo motena asem wesuo no ene wo abetutu bi e de ama mo pa ni na arrest warrant da Kevin Kobedu Taylor so ebuso ye free ne so no eno na kwame bafo Abronye chirimu wo so wonte ase ono mo nya adwene na we no we defend Kennedy akompreko Agyapong amafo bebre de Kennedy case bi de toto chese Kevin Kobedu Taylor ne nsem ya abeya yes a restaurant that is ye free ni sui and which was we inquired so first one Kennedy was some inquired no nkyere sebe or assembly no crowd na mo de compare Kennedy dinner on na ho and no ka say we defend Kennedy a compare ko Kennedy Agyapong and a breko na mususu no what to be e de ama Kevin Kobedu Taylor busua meso so be ka me ho na yakwa ko hwe video
say what nothing na say o say we NDC lawyer anti both MPP for be no more compare Honorable Kennedy, the fact that in what issue no more compares our cases in me no. Ye, media said the assembly no. The fact that in what issue in Chesa me who no kramenka. Said the assembly ana mekano. More compare Honorable Kennedy Agyapong case no to Kevin Taylor Diana. Ye, because Kevin Taylor case no time our mramu. Nana chiremu time our mramu and Timon and Trasi. Memen kasa menene wo issue ntinu na me de compare say Honorable Kennedy Agyapong ye binu Supreme Court kwase na NDC lawyers na post to social media say the same thing in the case of the Republic versus High Court expert Kennedy Agyapong mo compare bia mo sa lawyers na mo draw sa comparison mo law awu the facts of the case are not the same the issue ye kan wasem enye the same ayi Nyedi kan Kennedy Agyapong de no or attack judge no and a judge no issue contempt proceedings and a Kennedy Agyapong call Supreme Court within that month na no and a Supreme Court to quash judge ni decision no so fact Kevin Taylor de na the law of sexual right lawyers now omuntie me no they should quarrel and challenge me. Where a legal issue na ye kan wasem na yem fan hwese Supreme Court judgment no omu follow legal process ya na omu follow their own rules omu follow law due process no omu follow ya na enti Kennedy Agyapong de na ye that simple ya issue contempt and High Court issue contempt we did judge attempt into okwa Supreme Court to say woman kwase the judge ni ye no and okwa ye no wakwa we ni and alpha Kevin Taylor de na odidi judge na tem no and a judge ni issue contempt the law of contempt me pelo ya ni a obetima frame number na me de na call lie no aka say nyesa na tie the law of sexual right no se court to be a take decision na se decision no ene 23rd July 2025 and a judge say yemfa Abronye emra ewo nanim na Abronye ma kire die ntia yes atene contempt a enye yie. And now 23rd no me were up to 6 months to challenge the judge decision in the form of or by way of sexual right application And you take a decision in 23rd July 2025. Me was 6 months to challenge the decision by way of sexual right application until July to January 23rd, 2026. Not just say 6 months now, and Mrani Chile say judge be take a decision. Not say me person me go by sexual right application. The law is that you have 6 months. After 6 months, you cannot apply for sexual right. That is the law. Lawyer for them free. Number no, ewa free. Anafa message bra. Sameboa. That is the law of sexual right. Say, and 23rd, judge take a decision. Some person may appeal. Nam person sexual right and it say. Me kwakwa to a Quashed decision no different from appeal. Different from appeal. Appeal there wo for the entire proceedings in nyina say court no ntnase no nya re-evaluation. But when there wo say omunko to that particular decision ngu because baby atchema eno na ye call by sexual right application. Na mramunu time a wode be call for sexual right no e da ye take a decision no who was 6 months na wakwa ko challenge sexual right application no ofa Kevin Taylor de na ye take a decision no 2020 February 2020 and now 5 years near 5 years 5 months. Adia Mrani say you can only challenge a decision by way of sexual right application within a 6 months period. After the 6 months, I expire, you can only go for an extension of time. So, what Supreme Court wa? Supreme Court no mubu asem no. Where the High Court rules no, or 6 months to challenge a decision of the High Court by way of sexual right. What Supreme Court wa? The Supreme Court rules no. Emma ho kwan say ubekọ by way of sexual right application. You have 90 days. That is 3 months. Rule 62 of CI 16. Supreme Court man kasa womu di asem no womu wuru su ne say some person challenge decision bi e Supreme Court wa. Oh, 3 months to do that. In this case now womu di call Supreme Court no, it was a High Court decision. And it's a High Court decision there. So we CI 47 there. Now Kevin Taylor was 6 months to challenge that decision. Only 6 months. From 2020 to 2025. How many months? At therefore, Samna ye can ba Nenchira Munina no. And it's so bit Babina or criticize the Supreme Court ruling na say na 70 year. And until lawyers in Binum say, way a political judgment. Say na something that me probably about challenge me. Say some America me boa. About yes, Supreme Court wakasa. Obia ankwada. Wa officer yambe how no to bentwa. Esi unchen. Supreme Court wakasa. Uba wa. Ye de bentwa ne akaka duro betua. Ama koyirawa meswa kan ho bi. My ben ye say uba wa. Supreme Court de bentwa meswa akaka duro sri usa fam wisa nyina be kan ho. E de agya okwane. Asem ben ye. Until lawyers in Binum say a political decision of which I agree with them perfectly. Yes, you have 6 months, the statutory period within which to challenge a decision by way of sexual right. 6 months. That is statutory period. Case we had the whole 2020 up to 2025. 5 years, 5 months. na se 6 months no expire ye free be extension of time within which to file nti uba kwa kwasre court no say nanka me wo akwanya se me challenge decision no na mom enam circumstances binti akwantuo ni adwuma mu nti yade bi ebo minti no that 6-month period no mantimi an challenge decision no ama 6 months na so enti court no stand emra ne mame per the rules of the court no wo ho kwan se obehwe explanation na wode ama no na expiration na aka wa want man call for that application no na court no I extend no ma grant request na yede ama in this case Kevin Taylor one the most surprise thing is that Kevin Taylor and call for extension of time say 6 months period no awino into a court no say woman man extension one call because onimne na oye and one say what the dead application no court for sesorarai are within the law no awu and ye bisa say court no etimi nase esuomo 2 years say even though a time now we Kevin Taylor to come by way of sesorarai by your granting extension and watching your Quashed decision nana. These are the questions I say beside Supreme Court no, and we have every right to ask the Supreme Court questions. Criticizing the Supreme Court no does not amount to insult. Criticizing the Supreme Court no does not amount to insult. Yeah, me did judge be attempt to send Kevin Taylor. Did judges for attempt and my judge Barbie say Akrabini, one of the Supreme Court judges, you know, a chimpana. Producers monthly video no mara. On what kind? Or so my judge, you know, Kevin Taylor, and my judge, you know, 24-hour ultimatum say, Obeguna Nimase, judge, you know, what Supreme Court or your bar. Or say, I only a crabby chimpana. Yeah, my did judge be at no be not crabby chimpana. Would they demo any day them? I know you was him. And yeah, no, yaka. Now we have every right to criticize the judgment. Now, yeah, beside questions to say. Time Ben Kevin Taylor apply for extension of time within which to apply for to apply for a sexual right. Time Ben will apply. And it's court here on the court own motion and not grantee that extension of time now. I'm yet to receive the ruling. Our Tranapa. Near de bana de baba. Na ya baba mne mahwe how ade ne tie but o man court san hye ya me ka ho asem yi e bia no Kevin Taylor follow yes o 6 months deadline no atwam enti asa me call for extension of time wanye bibibia enti on what basis ana ne di kan cross Supreme Court etimi assume jurisdiction a determine matter no because the application even the application ankasa before the court no are incompetent. Application is incompetent. And how come a Supreme Court will preside over an incompetent application and gave a ruling to favor a Nipana or the incompetent application? These are the questions we should ask. One, the application is incompetent because 6 months period to apply for a sexual no, there was no extension of time for him to apply for that sexual right. And the court to know on what basis. Wamwana in their own motion, Wamaka say, even though Asukrana, Wama grantia manana, incompetent application. And ye bisa say, Inka yani bi, Obia only be